Hello, everyone. Welcome to Court with Krissy. What the heck? Could there be a connection? Who knows? But the money man is back, and he brought some friends with him. This time, the theft is because the man had to pay for his kids. The sailing isn't so smooth. They're all pro-per. I hope you like it. Court with Krissy is now in session.
All right, can everybody hear me?
Yes.
Yep. No, you two can.
Yes,
All right,
Judge.
what I'm going to do is I'm going to put the video closer to you so they can see you. There we go. Mr. Harrington, are you, I know you're ill, and I know that you're kind of dressing down today, but it's forgiven due to the circumstances, but I don't have a video, but I think honestly, there is a right for everybody to see.
All right. Hang on just a moment.
But I mean,
How's that?
yeah, that's good.
Thank you, Judge.
If there comes a time, Mr. Harrington, and you do need to perhaps not be seen and you would perhaps just like to have audio, I could ask and see if everybody's okay with that, okay?
The only problem we'll have is if I get to a coughing jag, Judge. That's when I'll have to step away for just a moment.
That's fine. If you get to a coughing fit, then I will know you're coughing. I will say off the record and we will briefly adjourn, okay?
Thanks, Judge.
All right. And victims represent themselves. No district attorney.
Morning, Olaf.
Morning.
All right, okay, so Mr. Hetchler,
Yes.
Clinton Hetchler, and Charles Anderson. And you're from 10th Hole, and I forgot your business.
Northern ATMs,
Northern ATMs.
LLC.
All right. All right, we will go on the record in the matter 24 CF10, State of Wisconsin versus Olaf Thomas III. Appearances are, we have appearing in person. We have victims Clinton Hetchler from Northern ATMs LLC. We have Charles Anderson from the 10th Hole Bar and Grill. And we also have appearing by video conferencing with approval of the court. We have Eugene Harrington, defense counsel, and we do have Olaf Thomas appearing we have him appearing from Jackson Correctional Facility. We have Tina Reinke, who is a representative for, is it Knights and Knights?
It's
Douglas and Knights Insurance.
yeah, Douglas Knight and Associate.
Thank you. Douglas Knights and Associates Insurance.
It's for Society Insurance. Yes, ma'am.
Oh, thank you. For Society Insurance,
Yes,
appearing by, right now it's video conferencing capability. If you are going to present any evidence or testify in any way or ask for, that would mean you would be asking for any type of reimbursement or restitution, Ms. Reinke, you're going to need to have a video so that everybody can see you, okay?
Yes, ma'am.
All right, so we're here today in this matter for a restitution hearing. This is one in which the state, the district attorney's office, is not representing the victims in this matter. The law provides that the district attorney's office does not need to, they're not legally required to represent victims in all matters. And this is one in which I believe that there was some conflict from the district attorney's office, and it was, I believe, confirmed with the state ethics that there is a conflict and it cannot be represented, at least by our district attorney's office. And therefore the victims are representing themselves. All victims are representing yourselves. That means you are pro per. That means you are going to be able to provide your testimony to the court more in a narrative, like a story fashion. All right. Mr. Harrington will still have an opportunity to provide objections if he believes what you're providing to the court is objectionable and cannot be heard by the court or considered by the court. At which time, if you hear an objection, please stop immediately so that I can rule on that objection. Once I rule on that objection, I will let you know whether or not to continue or to stop at what you had been testifying to. When you are done providing your testimony to the court, Mr. Harrington will be able to ask you questions as it relates to your individual claims for restitution. And you will then be able to provide a little additional summary to the court off of the questions that Mr. Harrington has asked to the court. You will also then be able to provide a closing argument to the court as to why the court should or why you believe you are entitled to the amount of restitution you are seeking. Before I begin, Ms. Bauer, can you please come up to this table? I have now pulled up the restitution supplement and it lists a Richard Bellinger, and that has cash for gaming machines. I do not have a Richard Bellinger here. Where is he?
I do not know, Your Honor. He was informed, and then I believe Richard Bellinger was going to have somebody come here in his place, and that person I spoke to this morning, and I do not see him.
This matter was scheduled for 11:15. It is now 11:26. Mr. Harrington, Mr. Bellinger is not here. He has requested restitution in the amount of $2,665.
Requesting, since he's not here, that his claim be denied.
The court, based upon his failure to appear here today, I find him in default. The court will deny his request for restitution. All right, so now we're going to move forward with regards to each other individual claim. It'll be one by one. Each person will be able to provide their testimony first. I'm going to ask, because there's three of you, who would like to proceed first? Mr. Anderson?
Okay,
You are Charles Anderson, spelled
Yes.
just the normal way, correct?
yep, I'm a
And you-
son.
What?
I'm a son.
Your son, yes. Okay, thank you.
Judge,
And you're
gonna
from
place him
10th
under oath?
Hole Bar and Grill.
Pardon? 10th Hole Bar and Grill, yes.
All right,
Judge,
you may
gonna place
begin.
him under oath?
Oh, yes. Everybody, all three of the individuals, Ms. Reinke, everybody, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may begin.
Um,
And so, you know, again, because you're representing yourself, you have the burden to prove to me with all facts and evidence that you are entitled to every single penny you are asking for. So if you do not prove every single penny you are asking for, you will not be entitled to that amount, okay?
okay. So where would you like me to start? When I got the
Judge-
call from the, from my
Judge, may I
security
interrupt
dispatch?
just a moment?
I can't hear you. Let me try and turn you up, Mr. Harrington. Can you speak again?
May I interrupt a minute? I think we can save some time here.
Yes, go ahead.
I've looked at the supplement to the dispositional order for restitution. Primarily concerned about Mr. Anderson, the cash gaming machine, they have $3,982. Other records reflect that that's $2,655. That's primarily what we're there for. And then the ATM replacement at $4,964. I want to know what the basis was at. Was it replacement value, cost to
All
repair,
right.
replace, whichever's less?
Okay, so I need to know for sure exactly where we're coming from, okay, Mr. Harrington?
Yes,
Your concern, other than now Richard Bellinger, that cash, that's no longer a concern. He's not here. So that is, no facts are presented. With regards to the restitution, you stipulate to all except for You have concerns and questions as to the value of that cash gaming machine, as well as that ATM and the replacement costs and all associated with that. Is that where
That's correct.
we are?
That
Okay.
relates to Mr. Anderson's claim. All the rest of the items are there and they are conceded. We conceded at the sentencing, stipulated to $9,000 restitution.
Oh, okay. So do you concede to Mr. Hetchler's claim of money for 467? It says $20 bills from the ATM for $9,340, return with ATM 2 hours, $300 for a total of $9,640.
Judge, you broke up. I missed a whole bunch of stuff.
I'm sorry. For Mr. Hetchler, he's requesting restitution for money, which is 467 $20 bills from the ATM for $9,340, and return with ATM for 2 hours of his time for $300, for a total of $9,640. Are you stipulating to that?
Not at the present time, Judge. If we can deal with Mr. Anderson first.
All right, but I believe the ATM, isn't the ATM owned by you, Mr. Hetchler?
Yes, it is.
The ATM is Mr. Hetchler's, not Mr. Anderson's.
I understand that, but the supplemental dispositional order had the gaming machine ATM replacement under the security insurance SI's itemized list there, Judge. That's what's sort of confusing.
It does. It does.
The insurance company paid that monies.
The insurance company paid to replace the ATM. It just didn't pay to replace the cash.
It didn't pay to replace, it didn't pay for the cash. It did not pay also for the travel time to put the ATM in and stuff.
All right, the ATM has been paid for. You're just wondering if that was a reasonable dollar amount for the ATM
Judge.
replacement?
Yes.
All right, so he's going to want you to explain pretty much, Mr. Harrington, so you know that I've had a similar case with Mr. Hetchler with a different bar for a different matter. So he wants you to do exactly the same thing that you did in that other case.
Yes.
Explain all of those things. Okay, and so with Mr. Anderson, you want Mr. Anderson to explain the gaming machine.
Yes.
But you don't need them to explain, or him to explain, his deductible, because his deductible is what his deductible is.
No, we concede that.
Concede to your deductible. So Mr. Anderson, all that Mr. Harrington is asking you to explain to the court in detail is that gaming machine and why it costs as much as it costs to replace it, which says $10,920.
I just put, that's what Rick told me, that they asked, the insurance company asked what it costs, and that's what I sent them. And then the cash is based on, when he went through the numbers on the machine, that my cut is 40%. So I took his amount and just figured what the 40% would be.
All right, but so the cash listed there is 40% of the cash from the gaming machine.
That was in the machines.
All right. So what you need to explain to the court is how you arrived at that figure for that gaming machine. Where did you come up with that amount to repurchase a gaming machine?
That came from the gaming people, Mr. Bellinger. And it's a separate contract, and that's what he had to pay. Under my contract with him, they're on my property, so I have to pay for them. But he had to purchase them.
You don't buy them.
No, he does. But I had to, they were under my responsibility, so I had to actually pay for the replacement.
Well, actually then, it's not for you to tell me how much they are or for you to explain to Mr. Harrington how much they are. You don't own them.
That's correct.
Your amount of $2,500 is granted. You're good to go. As far as I'm concerned,
My what now?
you're good to go. You're granted.
You're done.
Oh, okay.
Do you have questions for him, Mr. Harrington?
I'm not sure what you just determined, Judge.
He doesn't own the machine. Mr. Bellinger does.
Okay, so he
And
has nothing.
Mr.
coming to
Bellinger,
restitution.
and it's not his machine,
It's my money under the
but
cash.
it's his cash money. So I guess you can argue the cash money and why the cash money is in there. But if you were given that money back from the insurance company, but as far as the machine, he doesn't own the machine. Mr. Bellinger does. Mr.
So-
Bellinger was the one who received the amount to tell the insurance company.
Just to get this clear then, on the supplemental dispositional order for restitution, the ATM replacement is deleted. 4,964.
But we're not on the ATM yet.
On the
And
gaming.
here's the
I'm
thing,
sorry.
Miss Reinke's the one who's going to need to argue for her 20,000 or the insurance is 20,000. And she can call witnesses, she can call Mr. Hetchler, she can call Mr. Anderson, she can call Mr. Bellinger, but Mr. Bellinger isn't here, which is unfortunate for all of the folks. All right,
if I can-
so that's not going to bode well for all of the folks.
So Judge, if
Especially
Bellinger-
for the insurance company. All right, so sorry, but life is what it is. And Mr. Harrington luckily did not ask for this to be moved due to COVID, but I went to granted it anyway because it's had to be moved a couple times for not very good circumstances. It had to be moved. So
Judge, if I can clarify then, the claim for the gaming machine at $10,920, that is Bellinger's claim. Since Bellinger's not here, that goes away as well, correct?
well, it's not going to go away yet. Miss Reinke gets to see if she wants to testify and has enough to convince
Okay.
the court. Do
All
that in your transcript. Yes.
Can I clarify here that you're trying to lump the ATM in with Bellinger and all that? I have nothing to do with Bellinger.
Yeah, no, I think
Okay,
he's getting
all right.
confused. He's
Okay.
getting confused.
Yep, no, I know you understand it. I want him to understand.
I'm
that.
the only one that really needs to understand it.
The-
I'm all
Perfect.
here.
Perfect.
ABC.
The other
Yep.
thing is, if I might, Your Honor, that this has been moved several times
Yes.
and we don't put our business or our lives on hold, waiting for something like this to happen. So Mr. Bellinger had a cruise already planned for this weekend.
Then
and
unfortunately, he should have let me know. He did not. The
okay,
fact that it was moved before was an unfortunate death that I needed to move it for.
Mhm.
So unfortunately, sorry, I had to.
yep,
But the other reason I don't recall something about the prison.
yes,
So those are things that I can't control. This could have been controlled. I did not let and would not have let Mr. Harrington move it. It would have continued. If Mr. Bellinger would have said, you know what, Judge, I have this cruise. I'm going on this cruise. I've had it planned. You know, I'd love to still go. Can we move it? I would have graciously said, you know what? Yes.
Your Honor, Mr. Bellinger did tell me that,
Didn't tell me.
and he told me that he would have another person present today to cover for him.
Either way, he didn't tell me. And either way, he cannot do that because he's the one that owns the business. That's the thing. That's what the law says. You own the business. You have to be the one that testifies and does that. You can't delegate that. So, unfortunate circumstances. Not your fault, not my fault, not your fault, Mr. Anderson, or yours, Mr. Hetchler, or Ms. Reinke's. The court should have been aware. He should have written a letter, dear judge. So, the way the cookie crumbles. So, all right. We are where we are. So now I'm going to move on because I have Mr. Anderson's claim met of $2,500. I'm moving on to Mr. Hetchler, not saying that you're not done giving testimony. Ms. Reinke may ask you to provide testimony. Mr. Hetchler, we are on to you. $9,240. Go.
$9,340. What I have here is a
Plus 300 for your travel.
plus 300 for travel time. What I have here is I have a receipt from the ATM. This was pulled the day after or the morning of or morning of that they were looking for Olaf and the other guy. I don't remember his name, but anyway, this is pulled directly from the machine. It's a full accounting of what was placed in the machine, when it was placed in there, and what was left in after transactions from pulled out of the machine. And I gave this to the sheriff's office at the time that I took this.
All right. Are you asking the court to take that as evidence?
I am asking the courts to take this as evidence for my cash that was there, and then my 3 hours of travel time to get the ATM and everything of $150 an hour.
Before we move on to the evidence portion, you're going to have to very specifically in detail explain why you're worth $300.
I'm a master electrician. I do computer work. I do ATM repair also, and that is my billing rate, was my billing rate at that time.
At what time?
12/17/23.
All right.
It has since gone up.
What has it gone up to?
180 now.
All right. Okay. And so you're asking for 2 hours. Why?
Because that was the return time. I factored in that I had to go up there. This was just the return time to bring an ATM up. It takes 2 hours to get from my shop to the 10th hole. Actually takes probably a little longer, but that's the time that I set out for this.
So you only charge for the return time, not the initial travel time.
Exactly.
All right. Anything else you would like to tell me?
In regards to just this, correct?
And what you're asking for restitution, that $9,640.
I think it's a very fair, I have a clear and honest transcript from the machine of what went in there, what was used and what was left over after filling it. And I think I was extremely fair with my travel time. I did have to load the ATM and all that sort of stuff too. So I think I was very fair.
All right. What I'm going to have you do is take your document, bring it to the clerk. She's going to mark it as an exhibit. Mr. Harrington, I know you don't have the ability to look at that exhibit.
I
So
have
what I'm
copies of
going,
the documents.
oh, you do?
Yes.
Why don't I? I guess I'll
Judge,
receive
and
them now.
we concede that amount. There, we don't have.
I
any
don't have the
questions for
receipt.
This gentleman.
For you to look at it? You may look at it, yes. So I must have to receive it before I get access to it, if it's been filed already. Or you have it in discovery.
The victim's witness coordinator sent it to me.
Yeah, then you probably have it in discovery. I don't have it. All right. Okay. Mr. Harrington, do you have questions for Mr. Hetchler?
No,
You do not?
no.
Okay, thank you. Ms. Reinke, I'm now going to move on to you for you to go ahead and explain to me why the insurance company is entitled to $20,227.67.
Yes,
First
ma'am.
off,
Yes.
I don't know how many times you've provided testimony to courts. I don't know if it's the first time. I don't know if it's 20 times. So what I'm going to do is I'm going to have you tell me who you are and your association with the entity that's seeking this claim.
Yes, ma'am. My name is Tina Ranke, and I work for Douglas Knight and Associates. And we are affiliated, or we were hired by Society Insurance to request restitution for the loss that United VFW Post had lost from this theft on October 15th of 2023. On this incident, the property loss came to the $18,342.98. So from my company, Douglas Knight and Associates, first for the solar motion detector replacement, we have $19.99 for the motion detectors.
Well, I think,
Go ahead.
here's the deal though. I think
Yes.
that you stipulate to everything except for the ATM and to the gaming machine, correct?
Yes,
Correct.
that is correct.
All right. So all I need to hear about is that ATM replacement and that gaming machine, okay?
Okay, yes. Okay, so for the gaming machines, with that, they, for everything, it just, with what was replaced, it comes to, the $19,342.98. So we have what the insurance, I'm sorry, I apologize, the $20,227.65, what was paid out for the gaming machine replacement. That was, of course, for the $10,920. And then for the cash from the drawers, let me see. Cash from the drawers was the $670.94, and then the ATM replacement was $4,964. So that's what the insurance had paid out to replace those items that were damaged from this break-in at the VFW that were caused by Mr. Smith and Mr. Thomas.
I don't think it's a VFW, right?
Well,
I think it's
that's,
October of
well, the
23
insured,
either.
I apologize. Yes, I apologize. Yes. So we have, that's from the supplemental. I apologize. Because we have,
I think it's like
Yeah.
on a golf course or something or near one
yes, so I apologize.
and pool.
Yeah, the break-in theft for these two, yes.
Okay.
So that's what society had paid out for this break-in, and that's what we are requesting for restitution for them to pay equally between them two.
Mr. Harrington, do you have questions?
I do. Thank you, Judge.
Yes.
What was the value of the ATM on December 17th, 2023, when it was damaged?
All right, let's me look at this.
And if she needs to call witnesses, she will call them later. This is her time to provide testimony.
Okay. Can I ask the owner? I don't have that.
You may not. This is your
Okay,
time
sorry.
to provide
Yes,
testimony. If you don't know, you need to say, I
I
don't
do-
know that information.
I do not know that information.
Okay. then
After
my-
you're done providing your testimony, you will be able to call your own witnesses.
Okay.
Ma'am, how old was the ATM?
Let me see. Let me look at this.
Do you need to look at your documents to refresh your recollection?
Yes, if you can just give me a moment, that would be great. If I can
Once you
take a-
refresh your recollection, please put your documents back down.
Yes, ma'am.
If you don't know, you can say you don't know.
Yeah, I'm just trying to make sure. I don't see that it is, I don't think it was provided in this document that was provided. I do not
I have a
know.
question. I
Yes,
have a
ma'am.
question myself.
Go
So
ahead.
you work for the Douglas Knight and
Yes,
Associates.
correct.
You didn't pay out the insurance claim?
No, I did not. We did not. Society did.
So how are you asking for the money back?
So society did, they hired us to get restitution for this, to find the two individuals, the two defendants, and to submit all the documents to the district attorney's office if there was a criminal case. So that's what I do. And that's why we are involved with this.
But you have no affiliation with the actual claim that was filed, with the actual payout that was made, with anything related to the insurance, correct?
I did not pay out for that. No, I did not. Nope.
No, your
Okay.
only connection is you are a third party that the insurance company hired to say, hey, be our body, much like Mr. Bellinger wanted to have for him, be our body
There you go.
and testify, right?
Yes, ma'am. There you go.
All right, exactly. So you had no real connection, no real association
Yes, ma'am.
with this claim.
Correct. There you go.
All right, Mr. Harrington.
I move that Miss Reinke's company their claim be denied. They're not the real party in interest.
Granted. Society's claim is now denied. In full, granted. You are not the party at interest, Ms. Reinke. Neither is Douglas Knight and Associates. Not your fault. Not yours at all. Not Douglas's either, or Douglas Knight and Associates. Not at all. In a lawsuit, the real party of interest must be here to testify. You can't pass it off to another party. I can't say, okay, in my divorce, I'm going to have Vicky testify for me. Vicky, you're going to sit in for my divorce. Can't do it. I can't do it. If I'm in a car accident, I can't say Vicky's now going to be sitting in my place providing the testimony. It has to be the real party of interest. As much as this may not sound great to the parties involved, I'm sorry, the laws are the laws, the laws are the law.
Oh, I understand. But I appreciate it. Thank you.
And so, Ms. Reinke, again, not your fault, not your doing at all.
Well, thank
It's
you.
just society needed to be here themselves with one of their own to provide the testimony so
Yes.
it can be bing, bang, boom, facts.
Yes,
Mr.
ma'am.
Hetchler knows, he's been here before. I need the facts. I go A, B, C, D, put them together, need the facts, need it from the person.
Yes, ma'am.
So, again, not your fault.
Okay. Well, thank you. I appreciate it. Thank you.
So as it relates to the restitution, $2,500 is granted. And For Charles Anderson, 10th hole bar, $9,640 granted to Clinton Hetchler for the Northern ATMs LLC. All other restitution denied.
All right, thank you, Judge.
Do you want me to go into all of the findings? I can as to why, because it is, his conduct was the facilitating factor in this, or do you stipulate to all of that?
stipulate, I just want to put on a little bit of testimony about Olaf's ability to pay.
Well, yes, you can do that. And then I will go into all of the needed things that I need to go into.
Did you swear, Mr. Thomas?
Nope,
Raise your
Mr.
right
Thomas, please raise your hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may begin.
Thank you, Judge. You're Olaf Thomas the third?
I am.
You're the defendant in this case?
Correct.
You're currently confined in the, where are you at?
Jackson Corrections Institution.
Jackson? Are you working at Jackson?
I am not.
I have a GED from 2014,
That's correct.
36 years of age,
37.
37 now. 6 children still?
Yes.
Prior employment with Tero, T-E-R-O, Inc.
Correct.
And you were sentenced to, I think it was 2 in and 5 or 3 in and 5.
4 and 5-0.
All right. So you're about 1/3 through that now, aren't you?
Correct.
Do you think you'll have a job when you get out of prison?
I intend to, and I hope so.
Will it be with Tero again?
It will be.
And what's your average hourly wage when you work for Tero?
Probably about 38,
$30 an hour?
$38 an hour.
That's a lot.
And you have to pay child support for these children, correct?
Correct.
You made them.
The restitution is going to be joint and several obligation of about 9,000, almost 10,000. I'm adding one, between $11,000 and $12,000. Correct?
Yeah. Yes.
When do you think you're going to be able to start paying that?
I would say hopefully months after my release.
Yeah,
You know, like
all right.
anywhere from 3 to 6 months after my release.
All right. All right, I don't have any other questions, Judge.
All right, thank you. Well, I'm just going to go in and put on the record some of the things that I need to put on. Because criminal restitution by Wisconsin statute 973.20 is to be determined broadly. And I have determined it broadly. I've looked at all of the factors here. I've looked at the victims. I've looked at the crime. I've looked at the defendant, and I've heard all of the testimony that's been provided here today. I have to look at whether or not the defendant's actions were what's called the precipitating cause of the injuries complained of, and whether the injuries were the natural consequence of the action in order to find the defendant liable. It's easy to find in this case. He was found guilty. Well, he pled guilty. He was sentenced. He's in prison. He's accepting the responsibility. At the sentencing, he stipulated to at minimum $9,000. And here it's a little bit more than $12,000. I also have to find that there's a causal nexus between his actions and the damages, and that it was a substantial factor with regards to the damages. Now, here's the thing. I also have to consider other factors when I am doing a restitution hearing. I have to also consider the financial resources of the defendant and his present and future earning ability. I have to look at the needs and earning ability of any of his dependents and any other factors that I deem to be appropriate. Okay, and Mr. Harrington knows that he's very fluent in the law, that the law states that some financial discomfort to the defendant is consistent with the rehabilitative goal of probation and rehabilitation. And he also is aware that the court cannot state that restitution start after the individual is released from custody. DOC has the ability to start restitution up to 50% of all income, all wages, all money, all funds that an inmate receives, because restitution is very important. The key number one thing that the justice system looks at is the victims and making the victims whole, or as whole as we can. We can't fix everything. We can't fix the security of your bar or the feelings of the security. We can't go back and give you the things that were actually taken, but the justice system is there to try and do as best that we can to make the victims whole. And that's what restitution is. And I've heard the information about the incarceration. I know the incarceration that Mr. Thomas is facing or will be sentenced to or sitting. I sentenced him. I know how many children he has. That was said in a previous hearing. But again, Mr. Thomas is the individual who procreated, who had these children, who is responsible for the financial needs of the children, as well as for repaying this debt, the rehabilitation. That's part of the rehabilitation. That's part of making the victims whole. I have not heard anything that would deviate from the amount that the court has ordered. I have not heard anything to attempt to deviate from the amount that DOC would take as an inmate. And the court has heard that after Mr. Mr. Thomas is released from custody, he's going to, for the most part, likely go back to a job making $38 an hour, which is a very good job. That's a very good wage, especially as a felon, So the court is going to order, at least at this time, that the DOC has the ability to take what the DOC intends to take, or up to 50% of any and all funds received by Mr. Thomas in any way, shape, or form. And once he is released from custody, he will be on extended supervision for the period of 5 years. Extended supervision cannot be extended beyond that date and time unless he has another sentence, which is consecutive. But I believe his Polk sentence, if I'm recalling correctly, was concurrent and not consecutive. So I'm ordering at minimum $1,000 per month to be paid back once he is released from custody. If he is unable to pay $1,000 per month back, and he is experiencing what the court will define as a substantial and significant financial hardship, he must motion this court for financial review. And I will have a hearing. I will go over all of his finances. I will go over the debts, his income, his expenses, all of that, to determine whether or not he can afford that dollar amount. If he can, he'll continue to pay it. If he can't, the court may lower that amount to an affordable amount. I'm going to give the warning, though, that this has been asked for by other people, other defendants, who have indicated that they are not able to pay the amount set by the court. And after the court's review, I have actually increased the monthly amount. So you better think very hard about the ability to pay, but I am placing it at $1,000 a month because at that amount, the restitution should be paid off in full by the time he's done with his extended supervision. But again, if that's unable to be met due to a significant financial hardship, because he cannot afford to do that based upon his other debts and other responsibilities, this court will hear that and this court will modify that monthly amount. But until then, that is the court's order. But while he's incarcerated, obviously that is not the amount that will be received, because that is not the amount that he will make, because I'm not sure if the victims are aware, but they make very little, 50 cents an hour maybe, when they are working. So, all right. Anything that I'm missing, Mr. Harrington?
No, Judge.
All right. Anything else that the victims would like to place on the record? All right. Thank you. Then we are adjourned.